Emails show Morrissey paid close attention to online activity by Aiden Kearney.
Morrissey was in damage control mode throughout late 2023.
Special prosecutor Hank Brennan earned more than $500,000 prosecuting the case, which ended in Reed's acquittal on the most serious criminal charges.
A lot of the behind-the-scenes machinations and thoughts of the Norfolk County District Attorney in the Karen Reed prosecution have now come to light through over 4,000 pages of emails. And some of what's come to light is that D.A. Morrissey asked the state for $1 million for his failed prosecution effort. What we're talking about in this episode is the fact that District Attorney Michael Morrissey in Norfolk County, Massachusetts, had a lot of private emails going back and forth to various parties between Trial 1 and Trial 2 in the Karen Reed case. Those were requested by NBC 10 in Boston, the NBC affiliate in Boston. And those have come out. They were on, a lot of them, a private email account, not the DA's formal official email account, but what's called a burner account, because it wasn't his official account. It was an account that he went out and privately got. So the first thing that really came to light in these 4,000 pages is that Mr. Morrissey wanted the Massachusetts legislature to give him $1 million for this prosecution. Hey, I'm attorney Andrew Myers. This is our podcast about the law. Thank you for joining us. If at any time during this podcast you have questions, please let us know, and we'll try to answer them in the next podcast. But the first thing we're going to take a look at is some of the reporting on this. And again, it largely came out through NBC 10 Boston. And what they had reported is that in what Morrissey described as a perfect storm, draining the resources of his office, Norfolk County District Attorney Michael Morrissey requested $1 million of money from Massachusetts state lawmakers to bolster his prosecution of Karen Reed in her second murder trial. Again, that revelation came out of about 4,000 pages of Morrissey's emails sent from a private account. These were obtained by NBC 10 in Boston. They made a public records request, which anyone can really do. Morrissey, a longtime Massachusetts state legislator before he was first elected as a DA in 2010, sent the letter to the Massachusetts House Speaker, Ronald Mariano, in October of 2024, as Morrissey's office was preparing for trial number 2 of Karen Reed, calling the case, quote, the perfect storm. Morrissey went on to claim that a simple again, these are his words, not mine, that a simple domestic motor vehicle homicide case in Canton had blown up to national sensation. The time, the effort, and the resources his office has had to commit to prosecute the first case and now for a second retrial are substantial. And he reported to the legislature that it was a well-financed defense.
Trial, a perfect storm that blew up into a national sensation. Morrissey wrote about significant resources draining his office budget, all while taking on what he described as an unusually well-financed defense team. As we told you last month, Special Prosecutor Hank Brennan earned more than $500,000 prosecuting the case, which ended in Reed's acquittal on the most serious criminal charges. We learned late today that lawmakers approved a budget line item for the statewide District Attorneys Association, and Morrissey's office received $400,000 of that earmark.
So that's quite a bit of money to go to one district attorney's office for one case, but where he asked for $1 million and only got $400,000, we're sure that he probably wasn't very happy with that. To go on with the story, the next development was that Morrissey also wrote that his decision to appoint a special prosecutor would put a strain on his fiscal budget, as he requested a one-time allocation of that $1 million. The records that were produced confirm that Special Prosecutor Hank Brennan was in fact paid $566,000 $400,000 from taxpayer funds for his work on the case. I always question when you read, mass media reports, they'll say he was paid over $500,000 or he was paid over $400,000. They ballpark it. How much real effort does it really take to give the actual number, which was $566,000 from taxpayer funds for work on the case? The district attorney's office also spent hundreds of thousands of dollars on those expert witnesses and testing, according to invoices and trial testimony. The district attorney's office also, as we all know, spent hundreds of thousands of dollars on expert witnesses and testing, according to invoices and trial testimony. Yeah, remember the expert that put grease paint on the tail light and then, kind of leaned into it to see what he thought he could convince the jury would be a pattern of the injuries to his arm, and it was highly questionable, didn't stand up under cross-examination. And in my view anyhow, and I think the view of a lot of other people, that really did not convince the jury. And that was a key moment for the defense in the case. And as we all know, despite the spending of the $400,000, the legislature did kind of, I think, grudgingly give to the district attorney. Karen Reed, as we all know, was acquitted of the 3 major criminal charges against her, only being convicted on the drunk driving case. And, to spend that much money going after someone, I'm not saying drunk driving's right, but it was a very minor charge compared to the second degree M charge they were trying to convict her of. So Morrissey's request for the $1 million was followed by Massachusetts lawmakers approving a supplemental budget, is what it's called, with $1 million earmarked for the Massachusetts District Attorneys Association. A House spokesperson told NBC 10 Boston that the legislation was signed into law by Governor Maura Healey in December 2024. But where Mr. Morrissey wanted $1 million, the legislature in Massachusetts said, well, we'll allocate $1 million, but that's for all the district attorneys across the entire Commonwealth. And by the way, there are 14 counties in Massachusetts. And so he was lucky to get $400,000, 40% of that $1 million. So NBC 10 Boston received more than 4,000 pages of emails sent from and to Norfolk County District Attorney Michael Morrissey's personal account. Morrissey's office has not provided any statement regarding the use of a private iCloud account for official government business. Interesting. A spokesperson for the Massachusetts Secretary of State said private email accounts can be used. I question that, but the Secretary of State says the email accounts can be used if they are retained according to state law and provided via public records requests. One of Morrissey's major concerns revealed in the private, now public emails was his obsession with prosecuting the blogger that we all now know as Aiden Kearney.
The emails show Morrissey paid close attention to online activity by Aiden Kearney, the blogger known as Turtle Boy, who was one of Reed's most vocal supporters. On multiple occasions, the DA contacted the Attorney General's office to see if they would pursue witness intimidation prosecuting for things like holding rallies outside witnesses' homes. When he apparently did not get the response he'd hoped for, Morrissey expressed frustration to colleagues about Attorney General Campbell, writing, quote, "She has other priorities."
Well, yeah, the Attorney General, again, there are 14 counties in Massachusetts, and the Attorney General is responsible for all of them. And, they may not have been all in on this prosecution. And this fact that the Attorney General wanted no part of going after the blogger known as Turtle Boy, is kind of telling that DA Morrissey was really in it for himself. So now we switch over to news that we've derived from Boston Herald. Their headline was Norfolk DA Michael Morrissey's personal emails go public in relation to Karen Reed and other cases. What other cases? Stick with me. A slew of emails, they reported, from Norfolk County DA Michael Morrissey's personal account have come to light in regards to the Karen Reed, Turtle Boy, and other cases. Are you sitting on the edge of your seat yet? The emails from the DA's personal iCloud account were obtained by NBC 10 Boston, which stated they received 4,102, there's the actual number, folks, pages of partially redacted emails after filing a record request for any related to Morrissey's official duties as district attorney. The emails from Morrissey's private account included links to Karen Reed related and other news articles Morrissey shared with colleagues, regular notes to staff members to send sympathy cards in response to community events, and posts from vocal Karen Reed supporter and blogger Aiden Kearney. So that's a politician. That's what they do. They read the obituaries in the paper, and then they have their aides send out sympathy cards. So the question is, should the DA be doing this as part of his official duties as the district attorney of Massachusetts, or should he have a campaign office somewhere? He's up for re-election next year in the fall of 2026. And so, here he is using his private account. We'll grant him that, but I mean, he's very likely on the clock of the DA while he's having his people do this. So NBC 10 Boston Sue O'Connell explained that her review of the 4,100 pages showed a district attorney reaching out in many directions. And you'll remember Sue O'Connell was one of the reporters that actually sat through much of the Karen Reed trial in the courtroom.
I think it's clear to me that Morrissey was concerned about that federal involvement in the case. During 2023, he was actively trying to manage relationships with FBI leadership while simultaneously dealing with Aiden Kearney, a.k.a. Turtle Boy's public pressure campaign. And Kearney, of course, is facing several witness intimidation charges. And I think Morrissey was in damage control mode throughout late 2023.
So as you were going through these emails, I got to thumb through some of them as well. We didn't only see material related to the Karen Reed case, but a lot of other stuff, too. Anything there that's important we should pass along to viewers?
Well, that's debatable, Glenn. Morrissey actively shares obituaries with staff members, events that are coming up, job listings, potential office locations, and news about his office's cases. He has very strong opinions about Long Island. That's that Boston Harbor island that's was accessible only through Quincy. Morrissey believes Boston has been a poor neighbor to Quincy. And Morrissey also shared a Lexington town manager job posting with the Quincy mayor, noting it pays $260,000 for managing a population of 34,000. For context, Coke currently earns $159,000, but is asking for $285,000. And Morrissey has also reached out to journalists, including Yvonne Abraham at the Globe, Peter Lucas at the Herald, and he attempted to contact the New York Times' Carolyn Ryan through the New York Times General Help email. So he had a variety of interests, and he displayed them all in these emails.
Isn't that interesting that in his personal emails on the burner phone or burner email account, he's doing all kinds of stuff? Now if it's his private account and he is, asking to have sympathy cards sent out to people, I mean, who can say much of anything about that? But it looks like and sounds like, I mean, we don't know, but it looks like he's probably doing these things, while he's on the job, while he's in the office, as he's accepting pay as the sitting district attorney in Norfolk County, and there he is telling one city official about a job in another city. Is being a headhunter really part of being district attorney, or is it part of being a politician who's been in Massachusetts politics for decades? So, I found that really interesting. I found the emails really interesting. One thing that was only noted in passing in the reporting here, but they did noted it. We only showed part of those reports. One thing that was noted is that some of the pages were fully redacted or heavily redacted. So there is other material in those emails that disclose what Michael Morrissey, the district attorney of Norfolk County, was doing and talking about, and who he was talking to and what he was talking about. A lot has been redacted. So one has to question, what is all of that? So we move on, and I thank NBC 10 Boston for allowing me to use all of that. It's all very interesting. And someone had to make that request and probably pay a very hefty, copying and handling fee, which the law allows them to do. So as we know, Aiden Kearney, Turtle Boy, has been charged by the Norfolk County DA's office with witness intimidation connected to the Karen Reed trial. The district attorney's personal email became a subject of inquiry in relation to Kearney's case when Morrissey contacted a judge about a courthouse employee leaking information to the blogger via the private email. Following that incident, both Kearney and Reed's lawyers reportedly sought emails sent through the iCloud account. Kearney posted screenshots of over 20 of the emails to his ex account. You can go there and see them, and suggested that Morrissey used the account to hide communications, calling it a burner email, which is what it is. Among the screenshots, Kearney included a letter from the DOJ's Office of Professional Responsibility rejecting a request to review the federal probe into the Reed investigation, one to staff linking an NDAA training on citizen journalists, and many including links to articles on the Reed case. So people have reached out to the district attorney, Michael Morrissey, for a response to all of this. What's going on? Why was he doing this? What's his comment? And the Norfolk County District Attorney's Office said, quote, any response by the NDAO, which is the Norfolk County District Attorney's Office, will be filed in court. So we just have to sit and wait. We don't know what will be said. I would not hold my breath to see what Mr. Morrissey's response is, because, unless he wants to release a video before the first trial, which he did, he has been very silent, even to my request directly to him to explain a few things like, is it true what Vanity Fair reported that none of the top attorneys in the Norfolk County District Attorney's Office would try the case? They all refused. I contacted him. I heard crickets. Nothing back. So before we move on to our viewer comments, the other development that, if you're really interested, I'll talk about it more in our next episode. So let me know. In the civil case that is pending against Karen Reed. That's right. If you weren't aware, even though she has been acquitted on the major charges against her in the criminal court, there's a civil case pending against her down in Plymouth County. The criminal case was up in Norfolk County, which is south and in Metro West Boston. Plymouth County, as most of you know, is south of Boston. And there's a civil case pending against her. Now the defense team is getting very aggressive, and they have filed a motion to dismiss 4 of the counts against Karen Reed. I don't know. I've seen some of the coverage of it, and I myself personally think, I don't know if that's something listeners really want to see. Sometimes the legalistic mechanisms are kind of boring to a lot of people, but if you want me to talk about it, I will. It is 4 counts for emotional distress. Emotional distress is a tough claim to make. I've actually gone to appeals courts on the issue, and they're saying a couple of different things. One, Karen's defense is saying that the emotional distress claims would have been subsumed by the wrongful death causes of action. That means that the wrongful death cause of action would take precedence over the emotional distress claims, and they would be knocked out. That's one contention. The other contention is that the people that are bringing these claims were not in what's called the zone of danger. They were not there to witness whatever happened, whether it was a car accident allegedly or whatever it was. They weren't in that zone of danger. So if you want me to get more into that in another episode, I'll do it. Otherwise, I guess I'll pass. I don't know. So what are our viewers saying about all of this? Well, this goes back to our episode that we had posted on the Brian and Anna Walsh case. There's Anna down in the corner. So Arinerm, I never know how to pronounce these names. Arinerm 1331 says, it's not the lack of a body that is the problem for the prosecution. It's the lack of evidence. Assuming the judge follows the Constitution and case law on violations of it, That is the problem for the prosecution. Every bit of inculpatory evidence the prosecution has came from the poisonous tree, and the judge should find compelling reasons to exclude everything resulting from the illegal warrantless searches. Well, we did a very long 2-hour-long episode, which I will put a link to down below. And we read that the court did find that those searches were properly sought and received through search warrants. And so it was a well-reasoned decision. It went on for 36 pages. And I've got to say that I think the judge was right on that one. So I'm sorry. Number 4, a short one from Black Stump 172. The hacksaw with bits equals guilty. Well, we'll see. We'll see. One of the many pieces of evidence that was found in the searches for and about Walsh's body was a hacksaw which had bits of bone. So gruesome case. Number 3 from Linda Horton. Oh, I like a name I can read. Thank you, Linda. In my limited observation, if the evidence makes it obvious that the accused is guilty, the judge lets the evidence in anyway without a warrant. In the Karen Reed case, all that taillight evidence came in from an unsecured crime scene. The judge let it in anyway. Other cases, other judges have made similar decisions. Nobody makes it difficult, but not impossible. Well, I don't know about that rule. I've heard other people talk about it. If it's a case where it looks bad for the defendant, the court will let the evidence in anyhow, irregardless. And if it's a case that looks better for the defendant, they'll exclude it. That's kind of a shortcut, and I don't necessarily agree. I would say that most courts, and I've been in court in Massachusetts and New Hampshire for a couple of decades, and I would say that most courts, most criminal courts, do a pretty thorough analysis. And in my belief, the judge in the Walsh case did do a very thorough analysis of each and every one of the allegations that the searches, on the searches that Brian Walsh made after Anna disappeared on his son's, iPad. My opinion was that those analyses, one by one, were fairly thorough and would withstand review in the appellate courts in Massachusetts. So I don't think I agree with the shortcut, but I really appreciate your comment, Linda. Number 2 from Seb Midnight. I think if they have those Google searches, a body is not necessary at all. I would tend to agree. If they have to suppress those because a certain set of cops can't remember the most basic rules, the body becomes more important. And I agree. I think I kind of alluded to that in my previous comment. This is the same type of thing that upsets me about the Koberger case. Law enforcement, prosecution know the rules way before any crime is committed. Following those rules is important to protect all of our rights, but also to make sure the factually guilty face justice. I would agree with that. I think that that was well put in a relatively pithy comment. And this is what we're looking for, folks. Sometimes people give me comments that go on and on and on. And that's great. You should write a newspaper article or you should write a blog. That's great. But, we don't have time to get all that stuff in. So if you write me a long comment, we're just not going to have time. So these are comments that are perfect for this format. Finally, Tracy Talks a Lot, 1513 says, watching from Canada seems like a pretty easy thing to get a search warrant to go through the spouse's phone in a missing person case. How are they this lazy? The Google searches are weighty, so I hope the case doesn't crumble without them. Well, as was pointed out, they're contrary to what's been said elsewhere, there were search warrants, and although there was, in fact, a telephonic approval initially, there were also warrants, and so those searches, according to the court, were allowed. So we now move on. As we've pointed out before, we have now received comments and confirmations from people in 76 different countries. And we every week we seem to be getting more. This week from Scotland and Slovenia And so they were already on the list. But if you're in a country that's not on this list, let us know and we will include your country. So now we turn to the Koberger case and comments that we got on our last episode on the Idaho 4 case. People like Lynette Monty are saying, great, you're pointing all of this out. It's what we are all thinking. And this episode went to some comments that the prosecutor, William Thompson, had made, saying that now he thinks that there was stalking. Now he thinks that, in fact, Brian Koberger may well have gone into 1122 King Road prior to 11/13/2022, and that he bases on the complicated layout of the interior of that property. So Lynette Monty also says, I can't get my head around all the things which are said, but it's always with it's possible or we think or it might be. In a case like this where 4 beautiful souls were taken like this, it should be we know or very likely. So she says, like, where are the facts? The PCA is shocking now to read after everything now being backtracked. How is this happening? Good question. Good question. I agree, Lynette. Number 4, Ann Chick says, I am solidly in support of your position, R.E. Koberger guilt. Just too many questions, too many contradictions. There so should have been a trial. There so should have been a trial. Inflection is really important. I so enjoy your charming, humorous, and balanced channel. I look forward to watching for many more years to come. You are doing great work here. Thanks, Ann. We appreciate it. Every time we do this, we get maybe 2 or 3%, negative comments. But as long as people like Ann, and there are a lot of people like you that give us positive comments, we'll keep doing it. Number 3, Diane McGee. Just came across your channel. It's just what I was looking for. I've had to wade through some pretty crazy stuff, but at least I've found you now. Hey, thanks, Diane. It's good to hear an unbiased, articulated narration to this case. No crazy theories being spun. I've subscribed, and hi from Edinburgh, Scotland. Hey, 2 things to say about that. One, I appreciate the comment, and I'm not just putting them in here because they're self-serving. I want to point out that we feel that we are objective, and we have in the past, in the same episode, comments, been told that we are guilters and pro-burgers. It seems that people that have this confirmation bias and see things only their way, unless you go down that path, you're one or the other. And so we have, yes, been accused of being guilters and pro-burgers. And so we'll keep doing what we're doing. All right. Thank you. And the other comment I want to say is thanks for letting us know you're from Edinburgh. I went to Edinburgh as a college student. I spent some time in the UK, and I actually went through Edinburgh for a day and a half. What a spectacular city. If you've gone to all those other places in Europe, and seen the Eiffel Tower and all that good stuff, that's fine. But go up to Edinburgh if you want to see a spectacular city. Thanks, Diane. 2, Maryland Wildcat. I was wondering how you, as a defense attorney, had been. Now, okay, earlier in my career, I did do some defense. At this point in my career, I'm largely a civil attorney. I've made that clear in the past. I'm not trying to put myself off as something that I'm not. I am largely a civil attorney. I do things like, yes, personal injury. Yes, I do bankruptcy and some other kind of crazy civil litigation like property disputes and stuff like that. So anyhow, how have you been defending this case had it gone to trial as it should have, in my opinion? How would you have handled all the discrepancies that have since come out and would have been the prosecution's evidence presented during an actual trial? Well, you know what? We could spend all day talking about that. I am going to answer the question this way. You know how real estate agents say that there are 3 things that are important about real estate? Location, location, location. Well, there are 3 things that are important about any defense case, especially a case like this where there's just so many facts, so many documents, so many photographs, many of which are just coming out now and 2 come out in the future. There are 3 things that are important to a defense of a case like this: reasonable doubt, reasonable doubt and reasonable doubt. And although they have that, and I think their strongest piece of evidence is that little teeny tiny little bit of touch DNA on the brass buckle on the sheath, they were prepared, I believe, to really fight that. Some of us felt that they kind of, backed away from it at some of the earlier stages in the motion hearings. They had Bicca Barlow, who is a expert at DNA, and I think reasonable doubt is there with regard to that evidence. I'm sorry, but it's true. There's reasonable doubt with regard to that evidence, with the prosecutor, William Reed himself, saying that, we don't have a direct connection, although that's been disputed now. There's reasonable doubt. There's a lot of reasonable doubt with respect to all of the evidence. And so rather than pontificating all day in this episode, I'll just say that that is the most important thing in any defense, in any case, but especially in a case like this that this has so much. So that's my answer. Reasonable doubt. And number one, is that or unknown? Unknown. I guess it's unknown. Exactly. There is nothing credible about the prosecution. People just want the truth and to not have their intelligence insulted and some sense of a law-abiding judicial system. It's not about people having a morbid curiosity. And I would agree with this. A lot of people, some people have given us a hard time. Move on, get away from this case. Move on. It's all over. People have a morbid curiosity. No. People see a case like this, especially people that follow criminal cases, call it true crime, call it whatever you want. Read what they read, and they have a lot of curiosity about what is all this about? How can they say certain things and not back them up? So, yeah, we will continue. Let me know down in the comments whether you want us to continue to follow the Idaho 4 case or you don't want us to continue to follow the Idaho 4 case. I tend to think that we will because, as I pointed out in our previous episode, the Ada County Court in Boise is now starting that process. And we read an order that came out from Judge Hippler in which he listed documents going back only to June of 2025 through the end of August, July and August of 2025. That's only a 3-month period. And this case goes all the way back to November of 2022. So these documents are going to be meticulously reviewed by the defense attorneys and the state attorneys. And then at that time, and only after that review, will the Ada County Court release some of these documents. So that's going to go on for a long time. We now have the police reports from Moscow, Idaho. Pullman, Washington has released some very recently. A lot of photographs have been, released, but a lot of the documents that have been sealed over the last almost not quite 3 years are going to be trickling out. And so, yes, we are going to cover it, although I will ask you to comment down below. Should be. How much? To what extent? How much of this case should we continue to cover? And do you agree that we should move on? Because I'll tell you right now, I know who's not moving on, and that is the families and friends of the Idaho 4 victims. We always mention them at the end of our Koberger Idaho 4 episodes. And this case is very much on the minds of the 4 families of Xana Kernodle, Ethan Chapin, Madison Mogan, and Kaylee Gonsalves. And we remember them in every episode. And so, again, let us know how much you want us to cover this episode. Karen Reed case was over as of June 18th, but now a lot of stuff is coming out, including the emails that we covered earlier in this episode. And so, again, let us know what you want us to cover. We're looking at some other cases. Yeah, we know about the Morphew case, and we know about some other cases. So it's just a question of how much time and energy we're going to spend on those cases. So thank you for watching. If you've been with us for the whole episode, I think what we're going to ask you to do is to leave an emoji of an envelope, as in an email. I think there's an emoji for envelopes. And so send us an envelope, send us a mail, send us a letter emoji to let us know that you watched this episode all the way through. I'd like to point out, we love your comments. We really do. Be nice, be kind. If someone says something that you don't agree with, that's fine. Tell us why you don't agree. Give us facts. Give us law. Don't just say that that person's a moron, because you know what? Maybe they're not a moron. Maybe they're very smart. They've just, had a different background than you. They've got a different education. They've got a different view. So please, 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 please don't call people names. Be nice, be kind. The other thing I don't like, and I think you know this, is to say, you're an attorney, you. No, because then you subsume and assume that I agree with you. Maybe I do, maybe I don't. But if you say, you're an attorney, you, no. Tell me why you are telling me something. Tell me why, and give me some facts, or give me some law, or give me some other basis why you feel the way you do. So thank you very much for being with us. Be kind everywhere, anywhere you go, but especially down in the comments section. Have a good one.
Whether you are in the grocery store, the gas station, or anywhere else, please remember to be kind to people. You don't know what they're going through. And the same goes for our comments section. We want you to comment, but be nice, be kind, be positive if you can. And thank you for watching. Be sure to like and subscribe. Have a good one.